Does registration of a will make it valid? Many people believe that registering a will with the sub-registrar's office makes it legally valid and unchallengeable. However, that is not true. In India, will registration is optional, not mandatory. Even if a will is registered, it can still be challenged in court on grounds such as coercion or undue influence, fraud or forgery, lack of sound mind of the testator, suspicious circumstances surrounding its execution. The Supreme Court has clarified that registration alone does not establish a will's validity. This brings us to an important Supreme Court judgment that recently addressed this issue. Supreme Court judgment and key observations. In Leela and Ors v. Muruganantham Ors, Civil Appeal No. 7578 of 2023, decided on 2 January 2025, the Supreme Court ruled that the registration of a will does not, by itself, prove its validity. The propounder of the will must establish its due execution and dispel any suspicious circumstances. The court emphasized two key legal principles. 1. Proof of execution. Even if a will is registered, it must be proved in court through proper legal evidence. The attesting witnesses must confirm that the testator signed the will voluntarily and in a sound state of mind. 2. Suspicious circumstances and their impact. If there are any suspicious circumstances, such as the testator being sick or the will being signed in unusual conditions, then merely showing the registration document is not enough. The propounder, the person presenting the will, must explain and remove these doubts. The court ruled that if suspicious circumstances exist and the propounder fails to clarify them, the will can be declared invalid, even if it is registered. Now, let's look at the facts of this case. Case facts and Supreme Court's decision. In this case, the dispute was over a registered will that was being challenged by some legal heirs. Key issues in the case. The will was registered, but the testator's health condition at the time of execution was doubtful. The attesting witnesses' statements were inconsistent regarding whether the testator was in a sound state of mind. The will was executed in an unusual place, far from the testator's usual residence. Supreme Court's verdict. The court found that the attesting witnesses failed to prove the will's proper execution. Since the suspicious circumstances were not explained satisfactorily, the court invalidated the will, despite its registration. This ruling reinforces the principle that registration does not override the need to establish a will's authenticity. Implications of this judgment. Now that we understand the Supreme Court's reasoning, let's discuss what this means for people drafting wills. First, follow all legal formalities, ensure the will is properly signed and attested as per law. Second, registration alone is not enough. Even if you register a will, be prepared to prove its validity in court if challenged. Third, keep witnesses and documentation ready. Choose reliable witnesses who can testify if needed. And fourth, avoid suspicious circumstances. Draft the will in a transparent manner and seek legal guidance. Conclusion. To sum up, the Supreme Court's ruling in Leela and Ors v. Muruganantham Ors makes it clear that mere registration of a will does not automatically make it valid. What matters is proper execution, attestation, and the removal of any suspicious circumstances. Legal heirs can still challenge a registered will in court if its authenticity is doubtful. If you are drafting a will, consult a legal expert to ensure it complies with all legal requirements and avoid future disputes. That's all for today's video. If you found this information helpful, please like, share, and subscribe to my channel. If you have any legal questions, drop them in the comments below. Thank you for watching. See you in the next video. Till then, take care.